Good afternoon to everyone. At today's public hearing of the Vetting Commission, established under law number 65/2023, on the external evaluation of judges and candidates for judges of the Supreme Court. I am Marcel van der Wetering, the Vice Chairperson of the Commission and Chair of Panel D, and I declare this session open. This hearing is being conducted under law number 252/2023 on the external evaluation of judges and prosecutors and amending some normative acts, and under the Commission rules of organization and functioning as part of the evaluation process. The subject of today's hearing is Vasile Nogai, judge and former president of the Drochia District Court. And on 8 September 2017, Judge Nogai was assigned as president of the Drochia District Court. And on 7 September 2021, Judge Nogai was appointed to exercise the interim duties of the president of the Drochia District Court. Judge Nogai, welcome. I'm joined by two other panels. To my right, for you to my left, is Mr. Lilian, national member of the Commission, and Lilian Enshu, sorry. And on the other side, Yuri Gatkan, also a national member of the Commission. And behind you are representatives of the media and the public. Also present today is a photographer, as you can see, who will be taking photographs at the opening of this hearing for a maximum of 3 minutes. The hearing will be conducted with the interpretation between Romanian and English. And to allow for accurate interpretation, I ask everyone to speak clearly and slowly. Furthermore, the proceedings are being recorded, and recordings of this Commission public hearing generally will be available online at the Commission website www.vettingmd.eu within 3 days after the hearing. Well, I first will start by briefly reviewing the evaluation process for Judge Nogai. The Commission initiated its evaluation on 2 May 2025 by notifying Judge Nogai by email and asking him to complete and return an ethics questionnaire and the financial declarations required by law number 252/2023. Judge Nogai returned the completed declarations and questionnaire on 18 May 2025. On 30 May 2025, in accordance with Article 37, Paragraph 3 of the Commission rules, Judge Nogai was informed that his case had been randomly allocated to Panel B. On 19 August 2025, he was informed of the renaming of the panel from B to D, composed of the same members. And on 26 November of this year, he was informed of the modification in composition of the Panel D. The subject was duly advised of the right to submit a reasoned request for recusal should he consider such a measure necessary. As of this date, no such request had been submitted. As part of evaluating a subject's ethical and financial integrity, the Commission also obtains information from many other sources, such as the National Integrity Authority, the State Fiscal Service, the General Inspectorate of the Border Police, other public institutions, financial institutions, and open sources. The Commission assesses information it obtains for relevance and reliability. And between 28 July of this year and 3 November of this year, the Commission asked Judge Nogai to provide additional information to clarify certain matters during 3 rounds of questions. And the subject provided answers and documents within the given deadlines. On 28 November this year, we notified Judge Nogai that the Commission had identified and wishes to discuss some areas of doubt about his compliance with the ethical and financial criteria, and also invited him to attend the public hearing. Specifically, Judge Nogai was notified about the possible difference of approximately 1,200,000 lie between the income and expenses, and the possible violation of the conflict of interest regime. On 30 November 2025, Judge Nogai sent his response, confirming his participation in the public hearing, requesting the hearing to be held in closed session regarding matters relating to his parents and children, and requesting access to the evaluation materials. On 3 December this year, the Commission accepted the request for a partially closed hearing, and the Secretariat ensured access to the evaluation materials. On 3 December 2025, Judge Nogai submitted additional answers and documents requested that the hearing be postponed for a few days, that his parents and his brother shall be publicly interviewed by the Commission, and again that the hearing be held in closed session for the part relating to the private life of the parents and children. And on the 4th of December, the Commission accepted all these requests, informing Judge Nogai that the hearing is postponed till 12 December, so today, and that the interview of the parents and brother will be held in closed session. On 8 December, Judge Nogai requested that his brother is heard by teleconference, and on the same day, the Commission accepted this request. Judge Nogai, do you wish to make any corrections or additions to the answer you have provided to the Commission requests for information?
No.
I presented all the information to the Commission. In addition, I presented the reference because in the third round of questions it was my mistake, but I talked to the Secretariat and all the documents I sent with the reference. I don't have anything else. I will explain afterwards about the incomes, everything related to your doubts. Thank you very much. You are very responsive, so I'd like to thank you for that.
Okay, thank you. And are your answers provided to the Commission as well the information provided in the 5-year declaration and to the ethics questionnaire that you returned on the 18th of May this year still accurate as of today?
Yes. I maintain my position, which I indicated earlier in the reference.
Okay. Well, Judge Nogai, since we accepted your requests regarding the partially closed hearing and interviewing of your parents and brother, we will start this hearing in a closed session. So we can talk about the matters regarding your parents and children, and we can interview your mother, because I understand your father is not here because he's ill. That's right, huh?
I apologize. I have the mother is here. My father is older than the mother, and this morning something arose. But if possible, he made a statement on his own responsibility, attaching some documents. So I will attach that statement for the Commission. I just didn't want to take the risks because his blood pressure, he's nervous. If necessary, I will present his statement. The mother is here, but the father is not here.
Thank you. When we have finished the topics about your parents and children and the interviews, the hearing will be held publicly again. And when the public hearing is finished, probably it will be around 5 o'clock. We will interview your brother via teleconference, also in a closed hearing. And after this interview, the hearing will be public again. So you can, if you want, react on the statement of your brother and make a brief statement. Is this all clear for you?
Yes, perfectly clear. Mr. Nogai, and now I will speak about some issues related to the purchase price and sales price of some vehicles. I will speak about vehicle Peugeot 206, fabricated in 2003, which was purchased in 2013. You declared the purchase price of €2,300, and 2 years later, in 2015, you sold that car with $3.5 thousand, so $1.5 thousand more. At the same time, you mentioned that expenses for this car were incurred by your brother in Italy. Yes, indeed. And the income from the sale was cashed by you. how could you sell more expensive this car, and why did you take the income rather than your brother?
Da. Vreau să menționez, eu în runda de
Well, in the doubts round, I sent some pictures of that car. It didn't have some glasses, some mirrors, some other defects, and then my brother sent the spare parts in 2013. In the spring, he sent the car. We made the improvements, upgrades to the car. That's why the price increased. We did chemical cleaning, repair of the roof, and used the money because, as I mentioned in a closed session, after 2013, there were major changes in my family. My brother, since he knew the situation, that it's hard for me to deal by myself with everything, he left the money for me, for my family, for my children. So it was rather a donation to support your family, yes. He sends the car in order to use it when he comes here, but usually when he comes, he uses my car or our father's car. Who identified this car in Italy? He did, my brother.
Yes. So, did you use this car or not?
Very little I used it. It was mostly under repair. I used it very little.
Because I thought you said that your brother bought this car to help you because of your family.
No.
No, I apologize. My brother bought this car and sent it to the country in order for him to use it when he comes here. It was for a good price. So he sent it to our country. I did the customs clearance. I repaired whatever was broken, the mirrors and so on.
În total, cam care au fost cheltuielile?
And as a total, how much you spent to improve the state of the car? I can't say because I made some repairs at the mirrors. I have a neighbor in the village that does car repairs. He's now in Germany. He also does some electronics renovations for the car, so it was not a major investment. I don't know how much my brother spent on the mirrors because he bought them. In continuing, I would like to refer to the car Toyota Previa. You bought this car in 2015 with 5,000 euros, and then you made some improvements. You declared that you spent around 250 euros, and then in 2017 it was sold more expensive. So it was sold for 160,000 lei, which is around 8,000 euros. So the currency exchange for the lei would be around 50,200 and something. How can you explain how come the price increased in the meantime? Sure, I will explain to the Commission. When I bought this car, the seller told me that there is a defect at the engine because the price on the market was between 8,000 and 9,000. The car was brought into the country to the attention of the Commission in my declaration of 2016. According to the contract, the year is 2016, but I declared it in my declarations in 2015 as a year of when I bought it. And when I analyzed that I might do some improvements, and even if we all see the pictures, I took the pictures when the engine was taken out. It was a minor issue of the engine at the turbine. So the real selling price Yes, the real selling price was around 8,000, and then I gifted it. No, sorry, my parents sold it in fall 2017. And then your father gave you 160,000. Yes, my father gave me this amount. Because as my mother mentioned, the car was bought for the market. They wanted a bigger car. In the summer 2017, we went to Italy with my mother at the birthday of my brother. And my brother gave us some stuff, some gifts in the car. This 160,000 lei were were put on some deposit at the bank, or you used it to buy something else instead? No, this money were given to me and I kept them at home. In cash, yes. Thank you. I will continue to refer to the selling and buying of the car Mercedes 250. You declared that it was bought with 15,000 euro from a company based on the contract. Then there were some expenses of around 47,000. And then in 2023 you sold it for 40,000 euro, which means you sold it 25,000 euro more than you bought it, or 175% more than you bought it. Can you explain how this could happen? Yes, sure. How could you sell it for more expensive than you bought it? Sure, I'll explain. This car I bought. So some acquaintance told me about this car. I went to see it. It was a company car, as I mentioned from the data that the commission presented to me, and I verified. As I mentioned, the car was in a good state, no defects. And before buying, I did a test at the Mercedes Center. She went through some accidents, but still the price was good. This is why I bought it. But the car was not. It was not in such a good state as it's shown in the vertical car. I used it a lot in 2017. I presented it that in 2 years this car went through 450 accidents. There is the car. This is the official number of the accidents, and I mentioned that I invested some money in it, 47,000 lei. And in the question round, I mentioned that this was only a part of money because at the fiscal entity, I could not prove that the car was painted. I bought some parts from Romania for it. And all these improvements, renovations to the car, the fiscal entity did not approve because it was not written like at the Mercedes Center that these parts were belonging to this car. So the car was not in the car vertical, how it is shown in the car vertical works, big works were done to this car. Can you also tell me what was the reasoning of the company to sell this car so cheap? I did a request, and in the doubt round they told me why. So as I explained in the questioning round, the price was in between 20,000-30,000, and then after 24th of February, when the situation in Ukraine started, And also, there were changes on the European market and Moldovan market. The price increased. And the investments that I made into this car, I did not keep the receipts. And then the fiscal entity, when I did the declaration and I paid this official capital increase, imagine if I would have all the receipts on me, then I would have had a decrease for my contribution to the state. I tried to be as transparent as I could. Also, you told me that the company told you that this car is for sale. Was there an advert or something? No, a friend told me that the company wants to sell the car, and then the reason was that you have a family, you have a numerous family, so this car would be a good acquisition for you.
Yes.
Mr. Nogai, you just told me that when you bought the car, it was in a good state, huh?
Nu, eu am zis că mașina...
No, I mentioned that the car had some defects. Sorry, Mr. President. I mentioned that the car did not coincide with the information that the car vertical presented. The commission, or not the commission, I understand that the information is from the car vertical that there was no accident, that it is in a good state. It is not true. The car needed some improvements. I painted the front part, the back part, and then I spent money on the spare parts that I needed to change, and I brought these parts from Romania. I did not keep the receipts because the fiscal authority told me that they cannot take it into account because the number of the car is not indicated there. When I did the declaration, the income declaration, I asked this, they approved the documents for the amount of 47,187 leis, but the rest they could not approve because...
Do you remember what the rest was? Or how much it was?
Da,
Yes, that was my intention to tell. 200. So it's 60,000 for the painting job, changing of the wheels, because this car was taken from the company.
Do we have bills of it?
Aveți acele... I did not keep them. The other receipts, I didn't keep them because the receipts did not, the fiscal authority didn't approve these receipts.
Okay. And you send us information about the insurance company that paid in 2018 170,000 lei for the repair of this car. Do you remember?
Can you please ask again? I'm not sure I understood correctly.
In 2018, the insurance company has paid 170,000 lei regarding this car. And was this amount paid in relation to a road incident and the casco insurance?
Da, foarte corect, domnul președinte.
Correctly, you mentioned correctly. The company, so the car was under the casco insurance, it was repaired, and the company that sold it mentioned the visible defects, but regarding the hidden defects that you cannot see with your naked eye, which I discovered along the way. So let me tell you a situation, because I don't want to justify myself. For example, I was in Romania with this car with my children, and I had to use I used the brakes, And along using the car in Romania, I understood that there are these hidden defects that I could only discover driving it. For clarification, your total expenses for this car were around 100,000, right? So the repairs, the renovation, and to bring it to the necessary condition to sell it. Can you tell us, personally, do you know someone from this company where you bought the car from? Did you have some Did you have some lawsuits with the people from the company you bought the car from? No. Again, let's go back to 2023. After you sold this car, you bought a Mercedes V-Class from 2017. From the sources, from the income that you obtained previously, right? Correct. And the money from after you sold the car were transferred on your account? No, they were transferred to my account. The real amount I declared at the fiscal authority. Then you bought the Mercedes V-Class with 25,000 euros. Did you buy this Mercedes V-Class with cash or through transfer? Through transfer. So I paid 25,700. And 70,000 lei you paid for the importing. And then you also declared that 38,000 lei you spent to do some minor repairs. Sorry, I just want to, I just want to mention, having the experience with the first car, when I went to the fiscal entity and I did those declarations, I kept all the receipts. I kept all the receipts regarding the painting jobs I did to the car and everything. As follows, in 2024, this car, you sold it for 700,000 lei, which is 4,000 euros more expensive than you bought it. Can you also explain what was the reasoning of this price increase thanks to this investments that you did, the minor repairs? So this car also went through some investments. I painted some elements. So I spent so the car that came from Europe was better than the first Mercedes, even 50% better than the previous Mercedes. And I would like to mention that from the data presented to me, the car was actually, the selling price of the car was higher, but also thanks to the Commission and to the Secretariat, the information I received and I verified through Car Vertical. When the car was in the country, the mileage was 170,000. I don't really drive much, maybe around 10, 12, 15,000 kilometers per year, but the selling price on the internet, and when I gave all the documents to the buyer, the mileage was was inconsistent. When we look at the Car Vertical in 2022, the car had 329,000, and I bought it in May 23. You can see it's double, and then this is how we decreased the country. We agreed this with the buyer. The buyer showed me, that the mileage was double. And I think this influenced the price because I know that the car was bought from Italy, Milano, by a company in Bulgaria, and we know this type of schemes, how they go on. Do you have the confirmation regarding the double mileage? Yes, the car vertical. You can see this information in the car vertical. In the advertising that the Commission also presented to me, it's written 180,000, but I made my notes as well, and thank you for this information that was presented because it was very useful. The information presented by the Commission was very useful.
But when you bought this car, did you know about this problem with the mileage?
Nu, nici într-un caz.
No.
Mașina, eu am transferat banii când mi-au
No.
transmis pozele cu
When I received the photos
kilometrajul,
with the mileage, I sent
la preț,
the photos. I also
e prețul bun.
thought it's a good price, given the conditions.
Puteți să spuneți cum ați identificat
Can you also
acest automobile?
tell us how you found this car? Yes, through a friend
Trăiește în Milano.
that lives in Milano.
Și el, vorbeam cu el, că el exact așa
We
mașină
were
avea. Și zice,
talking, and he told me that he has the same car, and he told me that this car is on sale. And since I sold the other Mercedes, and also he came into the country and he brought this car.
Domnul Nogai, ca să totalizăm,
Mr. Nogai, to summarize, 2013-2024, in this period, you bought and sold around 4 cars. In each case, the selling price was higher than the buying price, including some repair expenses. Can you tell us? At the fiscal entity, you declared all 4 transactions? Honestly, the last 2 transactions I declared because the amounts were quite big as well. But in 2018 and 2015, I don't remember the law. I think it was not required. I don't want to lie. I did not declare it. After 2020, it was more strict. Even if we look at the income statement of the judges, they were simplified. But then in my statements, you can see that even donations, I did not declare them. So I started to do that from 2019. 2020, I didn't know that it will be part of the vetting commission, but I was even started declaring the amounts that I received during birthdays and other holidays, and since 24, of course, an amount gathered. Thank you, Mr. Nogai. In continuation, let's go through each year separately. You have the documents presented by the Commission in the notification. My incomes and expenses for every year. I will start with 2013. As you saw in the hearing notes, we identified inconsistency of incomes and expenses for the last 7 years. And I would like to start with 2013. Have you noticed that in 2013, the preliminary commission established an inconsistency of 137,030 leis?
Da.
Yes. How can you explain that difference? What expenses do you consider in surplus or are missing? In principle, I agree with the Commission's calculations, but I'd like to draw your attention to the fact that because the Peugeot 206 vehicle So the expenses for that car were inputted to me because I didn't spend any money. That car was bought by my brother. He will explain everything in relation to that car. Otherwise, I explained. In addition, for the expenses, so I made reference to the family code. Both parents have the right to support, and every taken by the. So anyway, there is a minus, but the amount is much lower. Even if we exclude this 58,000, anyway, we have a difference. According to my calculation, it's minus 55,000. I haven't included the donations or the support provided to the mother. Regarding the support for your daughters, we've discussed in closed meeting. We will not discuss that again. Let's move to year 2014. The Commission has identified a difference between income and expenses of 13,759 lei preliminarily. How can you explain that difference? I would like to draw the attention of the committee. According to my income statement, Nissan Micro was sold not with 2,000 but 3,000 euro. So if we take the amount was 18 and the exchange rate, we have a positive balance. Not so big, but 4,873 lei, according to the calculations. Originally, the National Integrity Commission, you declared this, that you sold it with 2,000 euro. I don't remember. I wrote that in the declaration. At that time, this information was provided to me because the car was sold by my former wife. Can you provide any evidence about the fact that it was sold with 3,000? Yes, I can. I know who the car was sold to, and he can confirm that indeed he bought it with that price. The money you paid in cash, yes, in cash, and it was sold based on a power of attorney. Now citizens understand that sale based on a power of attorney is problematic. Sometimes the cars could have some issues or can be pledged. That's why they need to be sold immediately based on other documents. But at that time, it used to be sold based on power of attorney, and the buyer was writing the amount he or she wished in the contract. This money obtained from the sale of your vehicle, you pretend this was 3,000 euro. Immediately after the sale, how were they used or kept? They were kept in the family, for the family, in cash. Yes, they weren't deposited. No, basically all the money. I have a big family, so I don't have any money deposited in accounts. We spend. Referring to 2015, preliminarily the Commission established that the expenditures exceed your incomes with 61,226. The same question. Could you please explain this difference? Yes, I'd like to draw your attention that in 2015 I purchased the Toyota with 5,000 euro. But according to the calculations, it was included 160,000 Moldovan lei. Which means, so based on my calculations, 100,000 Moldovan lei. Yes, 100,000. You declared this year a donation of 1,000 euro approximately. In 2015,
Au fost pentru procurarea Peugeot Biper.
For purchasing Peugeot Biper.
Au fost astea și
A fost un împrumut sau o
Was that a donation or a borrowing? That was a borrowing, a
Ce an
lending,
să
money lend. When did you return the money?
în 2000
In 2000.
atunci am restituit deoarece
I returned them
avea un
at that time because
frate îl trimisese un,
our brother
un
sent
scooter
a scooter, Piaggio Liberty,
și în locul
and
datoriei,
in the
ei au
place of the
cumpărat,
debt,
pentru
they
tatăl
bought the
cumpărat,
But this bipper was bought in 2013.
Stați un pic așa, soldul negativ.
So, okay, wait a minute. Negative balance. Look in the table for 2015, please.
Eu îmi cer, mulțumesc, domn
Oh,
președinte.
thank you,
Așa,
Chairman.
2015,
So, 2015,
soldul negativ
the
a fost,
negative balance was
61.000.
61,000.
Corect. Înseamnă că am vrut, domnule,
Mr. Yuri.
înseamnă că 1000 de
So it
euro
means
de la
1,000 euro from Nissan Micra
cheltuieli
plus
care
the
consumă
expenditures of
bani
the CEP for my mother,
și, da, să primiți
half of them
soldul
for the
negativ,
mother.
dar mai
Well, we have a negative balance still, but it's lower.
Ce în vedere
What do you mean? Half of the CEP, of the living expenditure, so the living expenditures for the children. I mean, when the calculations were done, me as a father, I mean, the entire amount was assigned, so half for the mother, half for me. We participated to supporting the children.
Da.
putem trece mai departe, da?
Da,
În,
Can we move forward?
pentru anul 2018.
For 2018.
Să vă uitați în tabelul din...
Could you please look in the table of,
Comisia preliminară a stabilit o diferență
we established a difference between income and expenses of around 100,890 Moldovan lei.
Să explicați această diferență.
Could you please explain this difference?
Da. Vreau să explic că Comisia
I would like to explain the...
ne uităm în
If we look in the calculations,
după mine
in my opinion,
pus prețul Peugeot
the price of the Peugeot Expert was included.
care el nici de cum nu mi-aparține.
And this does not belong to me.
Îi aparține de drept și de
So it belongs to my father, not to me.
eu dacă observați în
If you can notice in the income declaration, I was mentioning it as a car that I was using because there were some cases when I traveled with it abroad. That's why I was declaring it. That's why you declared it, because you only used it a couple of times? Even if I didn't travel abroad, anyway, there are cameras that could see it, but my father has all the documentation for it. As the mother said, they were traveling, using it to travel. Who dealt with the maintenance, changing the oil? My father. Technical testing, insurances. My father. I think there was some cases when I went for the testing as well, technical testing, but in most of the cases my father. He is still driving, although he has an age, but he still drives to the market. Coming back to calculations, in the table, as you can see, the difference is minus 100,000. If we exclude these expenses for the car, then you'd have a positive balance around 300,000. In the savings, you didn't declare this balance, neither in the bank accounts. So there is a hypothesis that you have had some other expenditures as well. No, this is money that we've collected and gathered, saved in our family. So the money, we have many children, and of course we needed to have some savings just in case of any illness, like it was the case of COVID. So at the beginning, in 2000, the state provided 16,000 to the people who got ill. But afterwards, well, we had an insurance, medical insurance, but everyone was doing as they could. So at the end of 2018, you didn't have any savings, neither in cash nor in bank accounts. Well, we had saving. I had saving, but I didn't mention that in the declaration. I had some money at home, but it was under the threshold for declaring. But in the round of questions, you didn't mention any savings. Maybe I missed to do that, because there was my wife who helped me, because there was a big volume, like filling in so many data in such a short time. It's complicated. Maybe other people don't recognize that, but I was helped by my wife. Now I'll speak about year 2021. Again, this year the Commission identified preliminarily a difference of 241,983 Moldovan lei between expenditures and incomes. Please look in the table, and if you could explain this difference. In 2021, you say, yeah. So the positive balance.
21, haideți încă o dată. Da. Deja e informație prea multă, dar mă stărui să o asimilez.
Too much information for me. So in 2021, at the beginning of the year, as I declared, I had a credit, the loan, the money used for the Renault car. So I had the loan, the Citroën and Peugeot Biper, who were sold. If we look, it was sold on the 27th of December, before the new year, in the last days before the new year. That was done based on a power of attorney, and the person registered it in 2022 because the technical documents expired in May. So the gentleman said, if possible, I will use the car until so I'll register the car when the technical documentation expires in May. I was showing that it's a loan, so the money, I was showing that I'm paying the loan. With the amount for the Citroën, it was 10,000 lei in the sales agreement, but the car was sold in the declaration of my wife because she was subject. So it was declared with 60,000 lei. But the wife provided a power of attorney, and the buyer, of course, when he registered it, in the contract he mentioned the diminished price. Of course, we sold it for the market price, around 3,000 euro. In the round of questions, you said that at the beginning of 21 you had savings of 330,000 Moldovan lei. In the round of questions, you mentioned that. Could you say again? Could you say again the question, please? So, in the rounds of questions, you declared that you had 330 lei at the beginning of 2021 as savings. Yes, from the sale of the Citroën, the loan, and the bigger amount of 170,000. 170,000 from the sale of the Peugeot Peter. The 100,000 from the loan. The loan from 2018, yes. Could you please explain what was the reason for you to take a loan in 2018 to pay the rates and to use that money in 4 years, after 4 years? Well, the car was bought on January 13, end of December. If you take end of December, so it's not 3 years, 2 years, 2 years, because the loan was contracted, so it's 2 years. Because the cars were put on sale. First, we put the cars on sale, and then I took the loan. And the cars, the Citroën was sold first, and then we entered the pandemic period, and then everything was blocked. Everything was blocked. And by the end of the year, transactions resumed. So why didn't you declare those savings in the declaration with the integrity agency or in the first rounds of questions? I declared the loan. I haven't even thought. I guess I just missed to do so, failed to do so. I thought that if I declare that I am paying for the loan, it means that the amount of money plus the sale of the Citroën. So in December, it's end of the year, I declared on the 21st. You mean in the round of questions? Yes, including in the round of questions. In the round of questions, I did explain. At the end, you only mentioned about these possible savings. It was my omission. So the cars were indeed sold. That's the reality. I probably, that was an omission of mine, non-intentional. About year 2022, I apologize. Hypothetically speaking, even if we speak about savings of 100,000, so if we take the loan and then the 10,000 or 30,000 for the Citroën, anyway, the 170,000, these are real money, because on the 27th, I sold the car on the 27th of December, and on the 13th of January, 27th of December 2020, and on the 13th of January 2021 is just a couple of days to buy the Renault Kadjar. So it's not even 1 month, not even 15 days. And even if we take this money, then the amount is smaller. It's not positive. If that was my fault, my omission, let's move to year 2022. In the table on incomes and expenses, the Commission established a difference of 532,991 Moldovan lei. Could you please explain that based on the expenditures and incomes presented? I'd like to draw the attention of the Commission for the expenses. You included not the price for which I bought the Mercedes 2016 with the price of 300,000 plus the upgrades, but the sales price was included. So you consider that the expenses of 300 were incurred. So the price for the bus plus the improvement, the upgrades. So the purchase price plus the upgrades done for that minibus. So 15,000 euro plus 100,000 you mentioned, yes.
Restul calculelor considerați că sunt corecte, da?
The rest of the calculations you consider to be correct, right? Yes. I would like to mention that the Commission did not take into account my donation. In that year, I had donations in size of 12,000 lei, taking into consideration the income of my mom, and if we judge by the calculations from the retail business my mom has, and the statistics of this business. I don't know why. Have you declared these donations? Yes, I did. Yes, of course. In my income statement, they are there. In my income statement, they're there, these donations. As well, I also declared donations of 40,000 lei from my brother in that year, but from some reason they were not included. You consider that they should be included at the income part? Yes, I think they should. All right. And the last year I will refer to is the 2023 preliminary. The Commission established the discrepancy of 160,000 lei. Yes, if you can explain this difference in some calculations. I would like to bring your attention to the fact that the same situation at the expenses, we have the selling price of the Mercedes, of the bus, the minibus, not the buying price. If we consider the 500 and something, then the custom clearance, the renovations, some repairs, then it's around 675 and something. So it will not be such a big discrepancy, more or less 25,000 lei, but it covers the situation. And as well, in 2023, you did not take into consideration the donations from my mother of 30,000 lei and donations from my brother of 60,000 lei. Thank you. I have no more questions regarding the discrepancies from incomes and expenses. If the colleagues have questions, you can go ahead.
Yeah, I'm having a look at the clock. It's a 5:45, and since we asked your brother to be available between 5 and 6 or 4 and 5 Italian time, maybe it's an idea to first hear the brother of Judge Nogai before we go on with the questions about the potential conflict of interest. So maybe it's good we have a pause for 5 minutes, so everyone can go to the toilet if they want, and we can make the connection with your brother. Yeah? Okay.
Yes.
Mr. Nogai, Judge Nogai, I'll have a few questions about the potential conflicts of interests. Starting with the first question. In your responses, you mentioned that in all cases examined with attorneys VN and IC, you informed the parties to the proceedings about the professional internship as a trainee attorney at law of your former and current wife in their law firms. And this was confirmed by the written statements of the attorneys, the judicial assistant and the court clerk, as well by fellow judges. However, in one of these cases examined in 2015, versus in the case VN versus AN, during the professional internship of your former wife A. Nogai, attorney VN was a party to the proceedings. And in this case, you issued a ruling to dismiss the application, arguing that although they had been informed, the parties did not appear and did not request that the case be examined in their absence. And in the hearing notice, it's on page 130 which is referring to this case. And my question is, why didn't you recuse yourself, given that the attorney VN was a party to these proceedings?
Da, domnul președinte, vreau să...
Yes, Mr. Chairperson. Now when the doubts arise, and I prepared the reference, I took the case and I understood. So this case indeed was randomly assigned through the ICMS system, and it was assigned for examination, and the notifications were sent. But as I saw from the parties were called, and in the first hearing, neither of the party has appeared. And the second hearing, again, there was nobody to announce. And the second hearing, again, I invited the parties, and again, they didn't appear. According to the Civil Procedure Code, when they are legally invited, so I dismissed the case. So this is what happened in this case. You could look in the ICMS to check on that, or you could. I took the case file. The case file is still available in the archives. No microphone is used.
Another case, which is referred to in the hearing notice in paragraph 295. In 2022, you were assigned to 2 cases involving MA, and in both cases, according to the PIGD, your ex-wife, Nogai, appears on the list of participants as a defense attorney. And in your responses, you did not mention anything about these cases indicated by the Commission in the round of questions number 2. And the question is, what were her procedural actions or her role as a representative in these cases? If your ex-wife represented the interests of the defendant, why did you not recuse yourself?
Mr. Chairman, I would like to explain. So if you look, there was a case in 2018 in Călăraș, where the cases were connected. A lawyer was my wife in one of the cases that were merged, and I sent the recusal to the commission, and the colleague said there is no reason, there is no ground. However, I announced the lawyers in the north zone to change the lawyer. I declared in the recusal I had to examine it, but in order to avoid conflicts of interest, I asked for the lawyer to change, and I continued the examination. So the case, having such a precedent and such practice, the cases were merged, joined, and I asked. So my colleagues told me about this practice, so I asked the lawyers to be changed ex officio, because she was participating ex officio. So I asked for another lawyer to be replaced. According to the ECHR and the Supreme Court of Justice, according to practices in 2024-2025, it is stipulated when the parties can abstain or recuse. So that's why I considered that no right is being violated. I am not examining anything personal. Me, as a judge, that's what I decided. Microphone is on. Microphone is not on.
Do I understand you right that you say, I haven't recused myself in this case?
I explained. In 2018, so I sent the statements and the ruling. In the Glodeni office is a small court. There are 4 judges in there.
10 ani sau
For
12,
10 or 12 years we've been working,
acum sunt 3 în 3.
2 or 3 judges.
Chiar în concediu lucrăm și câteva săptămâni.
When we are on vacations, there is only one judge working for 2 months, and we have a very big workload, caseload, and in order not to delay
Având practica de
having
la
such a
colegii
practice, my
mi-au refuzat
colleagues have rejected my recusal.
This case is in 2022, not in 2018.
Da, eu de asta
Yes, that's why I'm saying.
Domnul președinte,
Mr. Chairman, I will explain again.
tangență cu
I didn't have any relationship to that case. After the distribution by ICMS, I have a lower number of the case. That case you are referring to, it was assigned to another colleague judge. And then there were 3 cases. Those cases were sent for merger, to be joined or merged. And then the lawyers, when they were merged, the lawyers were different. The other ex officio lawyer participated. My wife didn't have any relationship to that section of the merged case.
The motion to join the cases.
Conform programului
According to the ICMS system, automatically the cases in the Chancellery office, so those who have a lower number, the cases are being sent, the lower number of cases, so the lower number was with me, but the case with the lower number, on that case, not my wife was a lawyer for that case.
So your former wife, Nogai,
Deci, doamna, soția
joined her.
posibil
maybe she did make a motion in order not to aggravate the situation of the defendant. Perhaps she did so.
And did she
dar n-a făcut
The chairman, but she didn't do the motion in my proceeding, in the proceeding that I examined. She did a motion in the hearing of another judge, another colleague, and the cases were sent for merger, for joining, and taking into account the practice of 2018, when the colleagues rejected my request for recusal, I wanted to avoid any conflict. I requested other ex officio lawyers for that case.
So in the 2 cases
Deci, în cele 2 cazuri,
of MA in 2022, Nogai was not one of the defense attorneys.
nu.
not one of the cases.
Dacă era, Doamne ferește, eu sesizam.
If she was, I would have notified, or as I did in 2018, I would have announced the union of lawyers. Please provide us another lawyer.
Okay, then the next case, that was in 2021. You examined the case and forced collection of child support involving your former court clerk NL between 2017 and 2019. And according to the information of the PIGD, the case was initially assigned to Judge IC, who self-recused on the grounds that NL was working as a court clerk in his office at the time. You examined this self-recusal declaration and issued a ruling accepting it. And on the same day, 16 July 2021, the case was assigned to you. However, you did not self-recuse. So can you explain why you did not self-recuse, given the situation that was practically similar to that of your fellow judge, in which case you decided otherwise?
Mr. Chairman, indeed, you correctly mentioned that clerk worked with the judge. With me, she worked back in 2019 after she left on maternity leave. As I mentioned, for the decisions of the ECHR, since October 2024 and October 2025, for the recusals of the wife or somebody of the staff members. This is not a reason for recusal. In that case, I didn't have a ground for recusal because the clerk was working with a different judge at that time. And within the proceeding, the fact that the clerk used to work with me, the former husband, it was about child support. The former husband knew that the lady worked with me. Not now, but then she used to be a staff member of the police. And she knew the judges being as a staff member of the police. And she didn't ask for any recusal. I didn't have any ground for recusal because we are not relatives. We've never participated in common events, or it was a
Former colleague of you.
Da, dar
yes, but the clerk.
Yeah. But how do you think an independent observer would look at this? The man in the street. You being a judge with a former colleague of you having a case in your court.
domn președinte, eu
I understand your concern. Somehow I understand your line of thoughts. But as long as me as a judge,
nu am n-am avut sentimentul
I didn't have the feeling that I am violating the law. I was correct, and her husband, if he had doubts, like the husband needed to have doubts. It was about child support. It was the child's right to support. So I didn't have any ground for recusal. Me as a judge, that was my my belief. If they wanted, they could ask for my recusal. Or if you look on how the proceeding went, they could complain or write a complaint to the Superior Council of Magistracy that their rights were violated. But actually, the decision was, the ruling was final. That was for the child support, and 1/4 of the salary was cashed according to the law. It wasn't a big amount. Or to favor him. He was hired, and 1/4 of his salary was dedicated for the supply in line with the law.
Another case, another question. CB mentioned in her written statement that during the period when she worked as a court clerk under your supervision between 2014 and 2017, before the start of the court hearing and the audio recording, you informed the parties about the professional relationship between your former and current wife and the attorneys VN and IC. A similar statement was made by NL, the clerk we just talked about. While the statements are plausible in the case of former wife A. Nogai, they are not plausible in the case of current wife S. Nogai, who completed her internship at the law firm of IC between 29 January 2021 and 29 January 2023. And given that between 2021 and 2023, CB and NL were no longer working under your supervision, on what basis are these statements made, which refer to an event that took place after the clerks had ceased to work under your supervision?
Da, eu înțeleg.
Yes, I understand. Thank you very much for this question. I'd like to draw your attention. Indeed, the clerks worked earlier, but there is a statement on their own responsibility of the court assistant, of the judge's assistant, who is still working. I'm trying to find the family. I'd like to say by letter. So the current judge's assistant, it was noted in the declaration on online responsibility, and that lawyer participated in 2 hearings. It has an office in Belzin municipality. And we didn't have any relationship other than just friends, some common celebrations or something like that we didn't have.
Okay. Then another question. During the question rounds, you mentioned that the information regarding potential conflict of interests provided to the participants in trial was not recorded in the minutes because it was provided before the opening of the court session. And the question is, don't you think this should have been done right at the start of the hearing and recorded in the minutes to guarantee your impartiality for an independent observer, as well as to note the participants' decision on this issue?
Yes, Mr. Chairman, I'd like to mention why I mentioned this, because since 2008 I've been working as a judge. At that time, at the NIJ, National Institute of Justice, there was Norlam program. We had colleagues from Norway who were teaching, training us, and at that time I was a judge. And this European practice, frankly speaking, it's a very good practice, because colleagues from Norway were telling us before the hearing, in their office, the lawyer, the prosecutor were coming to discuss about the evidence and so on. In Moldova, the practice of somebody coming to the office of the judge, that's impossible. It's not allowed, because if somebody comes in, there are suspicions. And I was doing that before the hearing, and I was asking if they recognize, for instance, if they recognize their guiltiness or not, or if I had any questions. I'm a resident in Glodeny rayon. If that was a civil case file, I was telling them, I'm a judge in the village X. If somebody knows, or you have or relatives, or if you have objections, you could ask for my recusal. Maybe I am a neighbor, but if you trust me, then we can open the session, the hearing. So that's what I was doing. There were a few lawyers in Glodeny rayon. At that time, we used to have 5 or 6 lawyers, and everyone knew. The internship is like it's an internship, and everyone knew that my former or my current wife is an intern. And I was telling them, if you have objections, and I took all the case files I examined. These are simple cases. You have access to them. About the child support.
The question is, why didn't you put it in the minutes, or why didn't you say this during the hearings, or, for example, why didn't you write it before the hearing? So it's clear for everyone that you spoke about this topic, and everybody agreed, because you know it's very relevant for judicial procedure, this information.
As I mentioned, Mr. Chairperson, as a judge, I thought I didn't have any grounds for recusal, because, as I mentioned in the previous decisions of the Supreme Court of Justice,
having grounds for recusal, it's about writing in your minutes or record it that you have spoken about this topic of impartiality, recusal.
Mr. Chairman, I understand your question, but that's the practice. Since I could explain for a couple of minutes. Since I used to be a court president, I participated in the model court program by USAID, and we had results per court. And the Glodeny office examined a hearing in 38 days. So we got a score per country, at national level, and at the EU level, the examination rate. And me as a judge, I considered that this is a good practice in order not to delay the cases, not to recuse. Because if the people don't trust me, they could from the very beginning ask me to recuse. So if I self-recused, then we would delay the cases exactly as in the situation in 2018 with my former wife.
As I said, it's not about the recusal, but it's about writing it down. Anyway, Other question.
Da.
In rounds 2 and 3, you stated that you knew RC, a former prosecutor, exclusively in a professional context. And in your self-recusal declaration in a 2012 criminal case involving RC, you indicated that you were friends and that you had mutual friends. In your responses, you mentioned that these were formulas that did not truly reflect a personal relationship and were used formally in a procedural context to ensure that the case was transferred to another court. The question is it ethical for a judge to indicate false or untrue circumstances to other fellow judges when resolving a self-recusal declaration?
Domnul președinte.
They were not false. It was for self-recusal. No intention to falsify was there. It was a reasoning case where a package of 2 judges were analyzed, where I was also there, and to not let it escalate. I understood this, but it was something I missed. It was an error, like a human error. But
What was exactly the error?
let's say a friend or acquaintance, it's actually 2 different things, but he's not my friend in any case. This gentleman submitted a declaration that it's also annexed here.
About this difference in
Deci, ce ține de...
what you wrote on your recusal form, and now you say he wasn't a friend of mine. That's right, eh?
Corect. Faptul dat a fost menționat.
This was also mentioned by this the person in the declaration. So in the round of questions, it was also annexed.
Yeah, but then still, you gave untrue information to your colleagues who had to decide about your recusal. Is that right?
That's true. It is correctly mentioned, but if I wrote acquaintance, colleague, we were still investigated on this case because it was a corruption case.
Okay, but you said yes, so that's an answer. And has this? Have there been other cases
Au mai fost și alte cazuri
in your career where
în cariera dumneavoastră unde a trebuit să faceți același lucru?
like indicating in your self-recusal declarations certain circumstances or facts that are not true?
No.
Situația dată a fost
This situation
a fost o situație force majeure.
was a force majeure situation
Era o cauză foarte complicată.
because it was a complicated case, and it was a set of 3 judges. It was a complex issue. It was not just myself in this case, for you to understand. I was not the decision factor. I was just a part of the set of judges, and there was a different person that reported this, and it was an exceptional situation where all 3 of us were, we had to abstain.
And in the last case, in the first round, you mentioned that AS is your goddaughter, from who you received certain monetary donations in 2015 and 2016. Also, in the first round of questions, you indicated that part of the funds for the purchase of the Peugeot Bipper vehicle constituted a loan, €1,000, from your godfather AS. Although in rounds 2 and 3 you denied any relationship of affinity, you did not explain why you used the term godson in relation to AS in your answers in round 1.
Da.
That's true. I'm not sure how this will sound, Mr. President, but as I mentioned from the beginning, when I was filled in the questionnaire, and my wife helped me fill the questionnaire, we were not aware of some aspects, because it is the godson of a ex-colleague. But I presented declarations, photos. I presented that we just know each other. We just know each other from the same city, but he's the godfather of a workmate, the godson of a workmate.
Okay. And can you explain whether there is a relationship between AS, your goddaughter, and AS, the godson of your ex-colleague, and what its nature is? Is there a relation between those?
Da, ei locuiesc împreună în Italia.
Yes, they live together in Italy.
Ei sunt familie.
They are a family.
Okay. My colleagues have questions about it. No. Fine. Then we post all our questions, Judge Nogai. And is there a brief statement you would like to make before we conclude this session?
Da.
Yes. Yes, Mr. President, first of all, an esteemed committee, I would like to thank you for your patience that you expressed today, and I also want to express my gratitude to the staff, the secretaries, because it's a great team, responsive. As I mentioned, I had missed many details, but with their help, I think that we managed to recover all the missing pieces, and we had the opportunity to bring in front of you all the evidence. And not lastly, I would like to thank my mother, my brother, and I would like to also apologize that they had to be part of this process, but this is also an experience for them in a way. And I also want to wish my colleagues, judges, and that participate in this vetting committee, because this is a life experience, this is a practice, and sometimes, Mr. President, as you also mentioned, some things look minor, but we learn. In a declaration, we sometimes, a word is very important. For me, is a life experience, and since May till now, it is important period. Thank you very much. I wish health to everyone, and thank you to all people that were responsive, because I know that this meeting will be online at some point. There were people that also gave their statement, and to people that somehow did me wrong. We all learn a lesson. We are people. A judge is just a job position, but we need to be human. And thank you very much, and good luck, success to the committee, to your families, to the secretary, to the staff, and God help us all.
Okay, thank you very much. Just to be sure, we haven't heard your father because he's ill, huh? You don't want to hear him anymore?
Eu am anexat
Yes, I also annexed the declaration on my responsibility. The girls from the secretary, they have this declaration. If I had to give it to you, I'm not sure, but the secretary has it. My father's also sends you greetings and good health.
Well, then we have come to the end of today's hearing. I thank you, Mr. Nogai, for your submissions and answers to the questions. And after the hearing, the panel will approve an evaluation report stating its conclusion, whether you meet the criteria for ethical and financial integrity under law number 252/2023. And the panel will strive to complete its evaluation report and announce its conclusion as soon as possible. So the hearing is now closed. Mrs. Nogai, also thanks to you for coming here. And I wish you both safe travels back home.
Vă mulțumim.